What is sham peer review? Sham peer review is the misuse of the peer review process to target a physician for issues unrelated to the quality of medical care provided by that practitioner. Sham peer review is initiated under the pretense of being quality of practice related, but has as its primary motive non-medical motives such as professional jealousy, personality conflicts, competitive business purposes, such as competition to be selected as CMO or to perform certain high-paying procedures. Hospitals or medical practice management may trigger sham peer review to silence a whistleblower or to choose sides on business-related matters. Institutional sham peer review is carried out by putting a red flag on the target doctor and encouraging staff, especially nursing and hospitalists, to file complaints against a doctor. Physicians have a responsibility to address situations in which individual physicians behave disruptively, that is, speak or act in ways that may negatively affect patient care. Physicians who strongly advocate or are self-assertive can be targeted with repeated reports of gruff behavior, rude behavior, or other personality complaints which, taken in the aggregate, are alleged to disrupt patient care. There are paid expert witnesses who publish poorly researched opinion pieces that masquerade as research, and these experts are prepared for a fee to render the opinion that a particular physician is disruptive. Disruptive behavior is different from criticism offered in good faith with the aim of improving patient care and from collective action on the part of physicians. Physicians must not submit false or malicious reports. Weaponized peer review is a perversion of this process so that sham peer review targets good physicians for non-medical reasons. Our image for this post is not a medical image. It is a hand holding a gun. You get the point. Sham peer review is like going to the parking garage and having someone put a gun to your stomach. It can be that sudden and that threatening, albeit to a career and not directly to your life. Sham peer review is an orchestrated abuse of the mandated process. It involves false accusations. Sham peer review is planned and often coordinated. If someone is keeping book on outcomes and documenting blame without an objective review, this is a classic sham peer review setup. Once the process starts, the ability to defend may be lost or diminished. Staff conflicts are weaponized. It is not outside our experience to see competing physicians or nurse versus physician conflicts being deliberately escalated so that complaints mirror each other. Interim steps such as PIPs, performance improvement plans, are Trojan horses. The target physician sees these measures as accommodative. They are usually not. They are a step towards suspension. You will not see their lawyers, but at a certain stage, the communications and decisions are orchestrated by attorneys who advise in the background. A medical defense lawyer can often tell when this is escalated. Summary suspension lasting more than 14 days is reportable. It can only be imposed when patient safety is immediately at risk, but to contest a summary suspension can take months. The result is often the resignation of the target physician, reporting to the National Practitioner Data Bank and/or medical board privilege restrictions and summary suspension. Sham peer review often involves very loose applications of standard of care. The standard is not applied objectively. The criticisms are fit to meet a standard of care failure. Sham peer review can arise from professional jealousy and competition for referrals. We have seen cases where a younger surgeon wanted training in TAVR, which competed with another MD, leading to retaliatory criticisms. Anti-SLAPP motions provide protections to the accusers and can result in the dismissal of a valid lawsuit and the assessment of legal fees against the doctor. In California, this can be financially devastating. Physician lawyers who are experts in sham peer review defense are necessary to challenge unfair peer review. Our lawyers have medical expertise, trial law expertise, and years of experience. State rules and HCQIA describe basic fair hearing requirements, including the right to a fair hearing, prompt hearings, notice of procedures, and notice of witnesses. The cardinal rule is that the best defense against sham peer review is early intervention. We are not perfect, but we have an excellent record representing physicians. Contact us today.